All right. So NewJeans announced that they're actually changing their name to NJZ, and in the midst of the ongoing Adore feud. So it's I think Rolling Stone and Billboard are the two major publications that actually picked up the news, and they had an interview in CNN. And this is CNBC Korea interviewing them. All right. So now, after that interview, Adore sent a letter to different media companies. It's a formal request to stop using NJZ and use NewJeans instead, because they're saying that this is still under their IP. They're still under contract with Adore, so they should be addressed as NewJeans. All right. Let me just put down my dog. You want to go down, baby? You want to go down? He doesn't want to go down. You have to go down. Say bye bye. Say bye bye. 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 Say bye bye. Say bye, man. Bye. He's like, why are you putting me down? Okay. All right. So now they Adore and Hive sent, well, Adore specifically sent a letter of request to all media companies to start calling them NewJeans, and don't call them NJZ. So the question a lot of people are asking is that, can Adore actually force media companies to use NewJeans instead of NJZ? Okay, that's a lot of people's question. Now, just want to do a disclaimer that I'm not a lawyer, so this is not a legal advice. Treat this as an initial research and should not be taken as a comprehensive legal study of the case. Uh, Much of this is based on research, also because I am in the industry, so I have access to lawyers. So I did ask them about these things, like exact provisions about the grounds or um, the regulations that Adore can use to force media companies to address them as NewJeans again. All right, so legal Adore and Hive might be able to sue a media outlet or anyone actually making public declarations not using NewJeans to refer to Adore's group. So they can. That is the answer. They can. They most likely will sue if a media company continues to call them NJZ instead of NewJeans. Okay, so what are the legal provisions? First is the trademark infringement if the name is legally owned. So they have to make sure that they own NewJeans and the entity and the IP of NewJeans. So if the entertainment company owns the trademark rights to a group's original name, they can argue that calling them by any other name dilutes the brand or creates confusion. Okay, so that's the arguments that they can use. If you don't call them, if you start calling Colgate like by another, like Arm& and Hammer toothpaste or something, then Colgate can actually sue and say, why are you calling us, or Sensodyne, for example. The, Colgate can actually say, why are you calling our product Sensodyne? It's going to confuse the market. It's actually Colgate. So that's the principle behind it. If a media outlet continuously refers to the group or the brand by a new name that is not legally recognized, the company may sue for trademark infringement or brand misrepresentation. Okay. Second grounds, contractual breach. If the group is still under contract. So if the group is still legally under contract with the company and the company holds the rights to the group's name, the company could argue that media misrepresentation undermines the contract and confuses the public. So kind of the same, but this one is focused more on the contract. So the critical thing is, if Adore is able to prove that the contract is still valid, then they have grounds to actually sue the media companies. Example is, if Adore is asking media outlets to continue calling the group NewJeans rather than NJZ, it is likely based on a claim that the members are still legally under contract with Adore. Okay. Next is defamation. They can sue for defamation if the name change implies false information. So, if a media company intentionally misrepresents a group's name in a way that will harm the brand or the agency's representation, then the company could sue for defamation. So, defamation basically means anything that could destroy your brand or destroy your name. So, if addressing them as new jeans undermines the brand of new jeans and adore, then that's defamation. So you're basically, the media is essentially saying that since you're not honoring the name that we gave them, it means that you're undermining my authority and the legality of our contract. So, okay, next, false advertising or commercial misrepresentation. If the media company profits from using the name incorrectly, like if they're selling a merchandise or tickets under New Jeans, then the company could claim false advertising or unfair business practice. I know a lot of you are going to ask, so this new festival where they're going to be playing, can Hybe actually sue them? Okay. If the media outlet markets New Jeans content as NJZ without legal recognition, then Adore could sue for misleading consumers. Now, this is not to say that the media doesn't have an out. They definitely have an out. They can defend themselves by invoking freedom of the press, which is very sacred in the US. If the new name is used for journalistic reporting, it may be protected under free speech laws. Okay, so if, for example, there is no malice in here, they're just saying that this group actually states that they are now NJZ instead of New Jeans, then the press, the media company can say, well, we are just stating a fact. We're not saying that they are NJZ. We're just saying that they are claiming to be NJZ. So they should be able to prove that there is no malice in what they are doing. Okay, so one of the defenses that they can use is the freedom of the press. If the media states that we're not saying that they are NJZ, we're simply saying they are claiming to be NJZ, that is the right of the media to report the news. So they can say, nope, that's just freedom of the press. You cannot control what we report or not report. Okay, next is, of course, context matters. So, if a media company clearly states that the name change is part of an ongoing dispute, they are less likely to be sued. So, if you would watch the CNN interview, I think it was CNN, in the last portion, the last part after they aired the interview, they actually had the disclaimer stating that Adore sent a request that they be called New Jeans. So, that is as EYA, a cover your ass. That is their way of trying to get out of a lawsuit. Okay. And next is, if there is no commercial use, if the name is not used for commercial benefit, then a lawsuit is less likely to succeed. Now, the question is, since CNN actually earns from the news, is that considered a commercial benefit? They can stretch. So the lawyer of Hybe or Adore can actually stretch it, but not usually. And then the other thing is the company, that's the festival that will actually have New Jeans um, as a headliner in their festival. Can Hybe or Adore sue them? Yes, Adore and Hybe can sue them. So most likely it's going to be a CDO, a ceased and desist order first, meaning they will request Hybe or Adore will request, or Hybe America will request the festival to stop it. Well, it's going to happen in Hong Kong. So they're going to request the festival to stop it. And if they don't, then they're going to sue. Now, the tricky part is, I believe it's going to happen in Hong Kong. And I am not sure in terms of the bilateral agreement between Japan and China. I'm sure about the bilateral agreement between the US and Korea, but not if it's China, and Hong Kong is a part of China. So, the final verdict, can Adore sue? Yes, Adore can sue if media companies use NJZ in a way that misrepresents the legal status of New Jeans. And they are most likely to succeed if they are going to prove that they own the trademark. So, Hybe and Adore, Hybe America should be securing the trademark of New Jeans in all countries. not just in South Korea. And I'd be very surprised if they did not secure that in the US and in the UK. However, media outlets can still argue and say that we're simply reporting the facts. So remember, in the US especially, freedom of speech is very much honored. So I'm sure that you've heard this before, but a lot of people will say, I don't like what you're saying, but I'm going to fight for your right to say it. So that's very much implemented in the US. You're able to say, for a time, it was like they were trying to censor speech and stuff. But for the most part, you're still able to say the things that you want to say without getting sued. That is your right. It may offend people, but it is your right to say it. So here, the media can state that, like, well, we hurt your feelings, but we're reporting the news. So the challenge now for ADOR is proving that South Korean contract is legally binding in the US, especially if NewJeans argues they are working under new agreements in the US. So the thing is that the US and Korea have a bilateral agreement. So many of the contracts in Korea, it is actually honored in the US. And many of the cases, especially if it involves a South Korean citizen, for example, judges will, and it happens, like part of the case happens in South Korea, judges are most likely to just refer that back into South Korea. So the question is now, what are you going to do? What is the thing that media companies are most likely to do? Are they going to follow what Adore wanted them to do, or are they going to continue addressing New Jeans and Jay Z? So ask yourself, if you're a media company or if you're an editor of a beat. A beat is like entertainment, that's a beat. White House, that's a beat. Police report, that's a beat. So if you're an editor of a beat or a section of the publication, do you really want to get sued over a group's name? Like, is that so important for you? Can you still report without defying the request of the company? Like for me, I'm not gonna get into a legal battle for a group against a big company in South Korea. So most likely companies are just going to follow the request of Hybe. And then once the decision is out, then they're going to abide by the decision, because regardless of what they call the group, it's not going to deter their ability to report the news, which is their job, right? So most likely they're just going to follow. That's certainly what I'm going to do. I'm going to report the truth, but I'm going to follow your request because I don't want to get into a legal battle with you. I go, like, media companies get sued day in and day out. This is not another one, for a group. Do they have, someone said that they have a financial backing of a Western company, primarily because they got interviewed by a Western uh, media company. I don't know who their backer is. I don't pretend to know. Probably they do. And you know that I've never wished them any harm. I want them to be able to continue their career. So if this is happening to them, if they are going to get sued, they are going to need a lot of money to pay the lawyers. So I do hope that they actually have a backing, because I wouldn't want them to touch their money, the money that they earned as New Jeans in the first 2 years of their career, because that's important, that they should be able to use that money to secure their future instead of spending it into something like this. And that is the advice that I would give. Like, if they were my daughters or my nieces, that's the same advice I will give. Like, if you want to fight this battle, don't spend your money, spend somebody else's money, not yours. The money that you earned, the 3.5 million they got paid in their second year, keep that. They should keep that. Like, keep that and use that for your future, not for a legal battle against a big company like Hybe. That is not how you do it. Just, if in the future you have a lot of spare, then yes, you can spend your own money for legal fees, but not at this stage in your life. Some are claiming that New Jeans will build a career in the US out of reach of Adore and Hybe. The question is, does the contract limit Adore and Hybe's rights over them in Korea, or does it also go in effect in America? And most, as I've said, Korea and the US, they have a bilateral agreement. So mostly judges in the US will actually just refer that to a US court, to a South Korean court. Now, the US court will not tolerate any violation against anybody's right, regardless of who you are, whether you're a citizen of the US or not. And there is a case here. If they know that your rights are being violated, then the court will actually step in if it goes to their table, in their court. But most of the time, they're just going to refer that. If no one is being harmed, if no right is being violated, they're just going to refer that to Korean law, to Korean court. So the question is, if what does the contract say? If the contract states that Hybe owns, or Adore owns the name and owns their contract in any part of the world, then that will stand, especially in the US, because the US has a bilateral agreement with South Korea. Do they have a shot in the US and Europe? Look, they have 5 songs which went inside Billboard Hot 100 in the first 2 years of their career. They are a successful group and they have a very strong fan base. No, I have never and will never claim that they are not successful. These girls are very, very successful. They have a strong fan base and they have a loyal fan base. They have stayed inside Billboard Hot 100 in total longer than like 90% of other groups in South Korea. So yeah, they do have a shot. And I hope that their fan base was BTS. And I hope that, according to One Hot Sean. So I hope that no one ever, like, I don't like, I believe in karma. So I don't like wishing people harm, because that's gonna come back to me tenfold. But more than that, it's just they are successful. So yeah, they do have a shot in the US. But let's also remember that Blackpink has way more entries inside Billboard Hot 100, have stayed inside Billboard Hot 100, both as a group and as individual members, but it's still not that easy for them. If it is, then they are all going to be, they should have, if it is easy for them after 7 years in their career, then they would be doing stadium tours right now. But it isn't that easy. It is not impossible, but it isn't that easy. That is Blackpink. Remember, they are they have they have done world tours. They have brand representation, I mean brand, they are brand ambassadors of some of the biggest fashion brands in the world. They have connections in the US. In fact, many of their hits, many of their entries inside Billboard Hot 100, it's actually a collaboration with many Western artists. That just proves that these girls know, they actually marketed themselves, and they networked well. And still, they're not doing stadium tours. Jenny, as of the moment, has two concerts, one in LA and one in LA. Sorry, one in New York and one in LA, and neither is sold out. It isn't that easy. They have a chance, yes. The same way Blackpink members has a chance individually, but it's not going to be easy. They need to get signed in by a US label. And the US label, whoever is going to sign them, that US label will have to be willing to go on a legal battle against Hybe. It isn't going to be impossible. Like if it is Universal Music, for example, something big, Columbia, um, whoever, I mean, they have a legal team under retainers. So maybe they will think, yeah, sure, it's worth it. Let's go on a legal battle. Let's sign them, and then let's let the court decide. Maybe. But there is also if you're a producer, like if you're the CEO, why not just wait for the decision to come, right? I'm like, okay, I'm interested in you, but let's wait for the decision, because I don't want to be paying the fine, like the penalty fee, just to break your contract with Hyde. I mean, that's what I'm going to do. I'm going to be meeting with you. I'm going to express my intention to sign you. But still, if it's like 7 months away, sure, I'll just wait for the decision. Or I can sign a contract. And in that contract will be a provision saying that I will not be responsible in paying your fees if you lose the case. Okay. Will the management contract between Adore and NewJeans be honored in the US? So these are the provisions, the enforceability, actual provisions of the case, the enforceability of ADOR's management contract with NewJeans and the US depends on several legal factors, including international contract recognition, jurisdiction, and the US labor law. Okay, so this is the actual provision of the law that will apply to this. In general, US courts recognize foreign contracts. Okay, in general, they recognize foreign contracts as long as they are legally valid in the country of origin. And in this case, the country of origin of their contract is South Korea. And they do not violate US laws or public policy. So if you are violating the rights of a kid, that's probably not going to be honored in the US because that's a violation of someone's rights. But generally, if you have a contract in South Korea, they will honor that. If Ador's contract with NewJeans is legally binding under Korean law, it can be enforced in the US through international legal agreements. Like, these are the exact provisions. The New York Convention of the Recognition and Enforcement of Foreign Arbitral Awards and the bilateral agreements between South Korea and the US on civil and commercial matters. So this is the strongest hold of HYBE. If they drag them to court in the US. If they start doing business in the US, if the NewJeans members start doing business in the US and they claim that, oh, we have the right to do this because in the US, this is the provision that that HYBE can use. Nope, there is a bilateral agreement, and in that agreement, it states that US is going to honor contracts that are done in South Korea. And South Korea is actually one of the strongest partners, like the long term, one of the long term partners of the US. Jurisdiction issues can ADOR enforce its contract in the US court. If the contract explicitly states that the disputes must be resolved in South Korean courts, then a US court may then refuse jurisdiction. Okay. So they can say, like, well, according to our contract, it actually clearly states that any conflict will have to be settled in South Korea. Then the court is just going to say, I get this out of my court. I have a lot of cases. I don't want to spend taxpayers' money. Okay. Um, Now they can argue against it and say that their US activities are separate from their Korean contracts. They can argue that, but that is going to depend highly on the contract that they have with ADOR. Okay. Even if the contract is recognized, this is what I was saying earlier, it must comply with US labor laws. So if the US court actually sees that the rights of the kids, of the five girls, are being violated, they're going to step in. They're not going to allow the abuse of women if they are getting abused or mistreated. There's also a 7-year law or a 7-year rule that allows artists to terminate contracts after 7 years, even if the contract states otherwise. A lot of people don't know this. But artists, when you are bound by a contract with a company, an agent, or whatever, 7 years, after 7 years, you can actually get rid of that contract and nullify it, even if the contract is still valid according to the contract, for as long as 7 years have passed. That's why ordinary contracts in South Korea is also usually 7 years. It's because of this law. U.S. workers' protections. If NewJeans claims their contract is exploitative, again, if they are being mistreated, abused, or whatever, the U.S. court will not honor that. And then, of course, there's visa and employment law. It's all going to depend on the kind of visa that they're going to have when they are in the US. They do have to get an O visa, if they're going to work as a creative person in the US. Okay, so I hope that addresses your question. Do you have anything else that you want to know about this case? I'm not a lawyer, so this is a part of an initial research. There are two channels in YouTube who are owned by a lawyer, and they actually explain these cases. I posted the link of one of them. I'll post the link of the other one. I think USA companies, Blue Side said, I think USA companies would be more reluctant to sign them. Groups are expensive, and USA companies don't know how to market them. That is true. Also, the other thing is, so yes, the primary concern is that signing a group is actually expensive. You're going to have to put money in it, and and that actually turns everything, like, if I'm going to put money in you and I'm not even sure if I'm going to be asked to pay the penalty if your contract actually gets nullified, if the court says that your contract with Adore is valid, why will I get into it? Why will I get into a contract with an automatic loss in in the beginning? So that's why I said, me, I'm sure that there are a lot of management companies or record labels in the US that are interested in them, but I think they will wait for the decision. Then it's a clean slate. If the court sides with New Jeans, then at least the the record label in the US will not have to pay anything. Bang Luna, could SK courts get a move and resolve this once and for all? I know, right? So they're so slow. Be reasonable. Said, I think it's too fast. Let's see. Jessica say, yes, US music contracts are very strict and binding, and their behavior of not honoring their contract makes them as a group very risky. That good point. That is a good point. As a company, I will also look at the reputation of the group, and recording companies, the recording industry isn't exactly in a great place right now. They definitely do not want extra expenses. Atlantic Records, which is the recording company, the record label of Bruno Mars, and others, they're actually laying off workers. That's how bad the recording industry is in the US. So why will they sign up another artist that will just be risky, right? So yes, that is a consideration. Okay. Leah said, okay, Carla Girl 7, how is Hanny working with her visa needing renewal? Who sponsored her? I don't know, but I said I've discussed that before. I think that visa thing is the least of her problems. um all she needed was like $750,000 to be able to get a residency, a permanent residency in South Korea, and she has that. All she needed was to actually store the money in South Korea, and South Korea will be able to give her permanent residency status, and that's going to allow her to do any kind of economic activity in South Korea. So I think people just blew it out of proportion. It's not really an issue. I think it's like one of the minor things that she had to deal with. If you have money, it's easy to get a permanent residency in many countries, not just in South Korea. The Bio Explorer, Carla Girl, there is a I discussed that in one of my live stream, and I also did a cut, like a shorter cut of that. And it was about Hanny's visa. You'll be able to, if you search it on my YouTube channel, you'll find it. The Bio Explore, okay. Clouds and Coffee, idol groups have an uphill battle in the West anyway. I think NJ is going to try to make it a move in China. Maybe they can probably make a move in China. It will not be a very welcoming industry. Not the fans. I think the fans are okay, but it's more about doing business there, because there is tension between China and South Korea right now. And I am assuming that the tension is going to be heavier because, as I've said, the US and South Korea are very close. And our president right now, Trump, is hell bent on doing things his way, which China isn't really happy about. So, so I think the tension is going to be like it's going to compound. Okay. They are using Hybe resources like phoning to promote NJZ, which makes me believe they will give Hybe a cut of their activities. Oh, I don't know about phoning. I think at the end of the day, and I've said this before in many of my live stream before, I think the resolution is going to be a little closer to the resolution of TVXQ versus SM. And that is, the court said, don't stop them from doing their activities. You need to allow them to work. But they also required the three members who nullified their contract, who terminated their contract, to give SM a cut of their pay, of their earnings, until they're able to pay the penalty. So she may already have done the Bio Explorer. She may already have done the residency visa and just not saying anything. I don't think she would have to tell Adore. That the Bio Explorer, that is also my God. That even before everything started, she already had that process. That's why she wasn't really nervous about it. That's just my gut. Either, yeah, probably before all of this started, she already got it processed. Thinking reality, I fear Jazzy J. Thinking reality, I fear for BTS when they come here to the US. Trump wants to help North Korea and pull military bases from South Korea and give five Korea tariff. That is not true. Um, South Korea is still a very close ally of the US. And I don't think that's going to change anytime soon because of geographic tactical moves. Um, the basis of the partnership of of US and South Korea is very strong because both countries are using each other for tactical reasons, military tactical reasons. So I don't think that's going to change. It's going to be very North Korea is not a very good partner for the US because they don't have as many resources and as much of a stronger economy as South Korea. So South Korea is more beneficial as a partner. Don't listen to things like that. I mean, BTS are still in the military, and so how are they able to book jobs without a door? Um, they have a staff. Remember, many of the staff of Adore actually went with them. So they resigned, remember? So they resigned from Adore and went with New Jeans. So these are the same people who already know how to book gigs to get brand deals. They've been working with Hive for a very long time. They've already probably developed their networks. And my gut is that many brands are just waiting for the resolution and then they'll sign New Jeans again. Again, New Jeans is very successful and they have a large fan base. So, um, okay, so Jazzy J said, I hope not, and I hope you're right. When it comes to big moves like partnerships with other countries, you have to like really think about what the US is going to gain. There's a lot you can say about Trump. This guy is by far not a saint, but one thing he knows is money. So he's going to be very practical about the use of that. Do they really have a large fan base? Bang Luna is asking, do they really have a large fan base? Um, for now, that's what the numbers say. That is what the numbers say. So they there is no way for us to prove otherwise, and the numbers say that they have a large fan base. So um yeah, so that is all I, I can say. Like they have a Billboard is a hard chart to crack, and they have five entries. So and they have, in terms of Spotify streams, they still are probably second to Blackpink. So that's like a huge lead. Maybe third after uh after twice, maybe third. And they're just 2 years old. So Rosie's asking, I thought they still needed to ask for permission from Adore for the visa. Granted, they didn't consider Adore their employer, but I remembered reading that somewhere. Um, if you're going to, as far, I'm not a lawyer, but if you would remember, there I did some. We're trying to do some business with South Korea, so I kind of had to go through some things for visa processing. I can't say much, but you can concurrent. You can do two things at the same time. So you can process your well, not O visa, but your employment visa, and you can also process your permanent residency.